We'll go on the record in the matter 25 CF 54, State of Wisconsin versus Zachary Chaffy. The state appears through District Attorney Kevin Schmidt in person. Mr. Chaffy appears in person with his counsel, Shirlene Perrin. He is also in custody. We're set today in this matter for the sentencing portion of this case. Mr. Chaffy pled guilty to manufacturing, delivering designer drugs less than 3 grams, a Class F felony as a party to a crime, maintaining a drug trafficking place, an I felony as a party to a crime. The court ordered pre-sentence investigation report. The court has received and reviewed that report. Defense ordered an alternative pre-sentence investigation report. The court has received and reviewed that report. Nothing significant stood out to the court as being a mistake. But Mr. Schmidt, did you receive copies of both of those reports?
I received them. I don't have corrections per se. I'll disagree with you.
Okay. Or we lost power apparently.
Sorry.
Again.
Did you hear me for that? Penny Hagen. Okay.
All right. Ms. Perrin, did you receive both reports?
Yes.
And do you have any corrections or material alterations that need to be, or modifications that need to be stated on the record?
No.
All right. Then we can proceed with sentencing and recommendation, Mr. Schmidt.
Thank you. State's going to be arguing for 2 and 6 out on the manufacture and 1.5 and 2 out on the maintaining a drug trafficking house. The reason for the difference in the state's recommendations in this case versus the one with Chamberlain is based purely on the criminal history. You can see from Chaffy's criminal history that because of his interactions with the criminal justice system, that he has more reason to know better. He's been to prison before. He's a felon, so he knows he shouldn't be around firearms. That being said, the reason for the discrepancy between the state's recommendation and DOC's recommendation comes more from DOC's summary and conclusion section. DOC made a number of assumptions that are mistaken, which I'm sure the court probably already caught since we did Laura Chamberlain's sentencing and I already pointed these things out. First, DOC assumes that these convictions or this evidence is indicative that Chamberlain and Chaffy were distributing DMT, dimethyltryptamine, into the community. The second mistaken premise is that DOC had indicated they believed the substance was dangerous and addictive. We know this because in their basis for recommendation on page 24, they wrote that as part of why they gave the higher recommendation, they believed that this behavior contributed directly to the increase of illegal drugs in the community and created an unsafe environment that promoted cycles of addiction and harm in the community. And the second thing they indicated was that they believed that this substance, dimethyltryptamine, is dangerous and addictive, same page. So first of all, I'm going to briefly describe the facts of this case as they all played out. Police came to search the old bank in Grantsburg sometime after the property was transferred through a divorce proceeding between Laura Chamberlain and her ex-husband. She was living with and allegedly renting space to her boyfriend, Zachary Chaffy, in the same building. Per records of the family court case, big part of the fight between the Chamberlains was about some firearms that belonged to the husband. I guess they had custom features, so there were a lot of visits for assessors to look at the firearms in this place, and Zachary Chaffy was present. When we were doing the motion based upon the motion in this case, the state collected a lot of the family court documents. So it was well known for a long time these guns were there, and so was Zachary Chaffy. The ex-husband, when he seized property on the order of the Polk County Court, found a number of suspicious items, including what he believed was some sort of lab. He asked the sheriff's office deputies to look at it. In our area, we have a lot of methamphetamine. We have past experience with methamphetamine labs. We have experts on what methamphetamine labs look like. They looked at it. They said, this is not a methamphetamine lab. And it was just left to be. Later on, a Grantsburg Police Department officer had occasion to look at the lab, and she, along with a different deputy, caused the pictures to be sent to the Department of Criminal Investigation. They quickly recognized it as equipment to create dimethyltryptamine. They also said that there are some chemicals there that could be used to create the Cold War era poison ricin favored by the Soviet Union, which is kind of an oddity. Police executed a warrant based on the information. As soon as they checked the lab, got in, and weren't just working off of photos, that is, once the clear team with the experts got in and looked at it, they quickly saw like it didn't have the other components to make ricin. You can make a lot of different things with a lot of chemicals, so they don't think they're making ricin there. They also confirmed it was a dimethyltryptamine lab, and the way the lab was going and the way dimethyltryptamine is created, it is not a dangerous type of lab, so they removed the PPE before they even started removing the equipment from there. Big difference between methamphetamine labs and dimethyltryptamine labs is methamphetamine labs involve substances that gather energy even in the air so they can become explosive. They also involve chemicals that can very easily scatter and be corrosive and contaminate the environment. Big difference with DMT, where the biggest difference of the biggest danger of the lab is that inherent with using a pressure cooker, and you use a really basic substance at one point in the manufacture. Basic in terms of the opposite of acidic. That being said, all the chemicals and substances we found that were used in the creation of it were substances you can just buy legally. DCI believed the substance they found in the jars that formed the basis for the offense, this biphase substance in these jars, was DMT in its final stages. The state lab confirmed it is DMT, dimethyltryptamine. DCI was surprised that the one thing they didn't find is some of the equipment for like one last step that would have involved creating it, really condensing into like a crystal form, and we never found any final product of it. We also did not find large amounts of cash on it. That is, the jars that were found were the final stage of making it. To this day, no law enforcement in Burnett County has actually found somebody possessing dimethyltryptamine. Nobody in law enforcement knew what it was before we found it here in this case. The way the Department of Criminal Investigations originally described it as a designer drug, and they said it was used as like a party drug where people abuse it. They said that basically it causes a psychedelic trip akin to mushrooms that is more controlled, lasts in short bursts, more like 15 to 20 minutes. In her allocution, Laura Chamberlain admitted they were making dimethyltryptamine, but said it was for personal use. She said they were kind of experimenting with it. This is echoed in Chaffy's statement to the PSI writer. He says something very similar. Chamberlain's explanation of them kind of just looking up online and ordering the materials and trying their hand at it helps explain why some of the equipment for the very final step was missing. They probably just didn't know, and also explains why it ended in this last phase before the final pull. That is why you'd have so many of these jars and not pull the final product off of it, because they thought they didn't successfully complete it. We heard that from Laura Chamberlain. So that actually helped explain some of the evidence, I thought, in a way that I thought was pretty compelling. In preparation for this case, when it's set for trial, the state conducted its own research and further consulted with DCI, because doing the trial would necessarily require explaining how do you generally make dimethyltryptamine and how each piece of equipment and chemical in this lab would be used to do it. And also for sentencing eventually, since I knew this court wasn't familiar with dimethyltryptamine, what are the risks associated with it? How dangerous is it? We treat different substances differently. The way we sentence THC is different from meth, is different from fentanyl. And that is when conferring with DCI, the state discovered that DMT is extremely easy to be made. It naturally exists in nature. Really what you do is you concentrate it through a different process. As also when the state came upon Gonzalez v. O Centro Espirita Beneficiente União do Vegetal, which is 546 US 418, Perrin 2006, and Perrin.
When we're done, can you please make sure that the spelling is to the court reporter?
I will. That was the 2006 Supreme Court of the United States case, which dealt with whether the government could just blanket ban dimethyltryptamine through the Controlled Substances Act. The lower courts found that because it had a long tradition of use in cultural and tribal practices and was being used in the southern United States for religious practices, that is, as part of sacrament for some churches. For the government to be able to ban it, you have to do rational basis review, which involved weighing the pros and cons of the substance. The lower courts found that the pros and cons of the substance were equal. That is, it's a substance that naturally occurs. It's not addictive. It doesn't have a high risk of overdose unless you mix it with other things. The highest health consequence is really someone having a bad trip, or more physically, just high blood pressure. As a result, the Supreme Court of the United States adopted those courts' position and found that you can't just flat ban it. You can have religious exemption and possibly others. It's kind of treated the same as how peyote can be treated. I bring that up because it helps demonstrate that the Supreme Court of the United States has actually made factual findings about the level of dangerousness of the substance, the addictive nature of it, which is not high. That's why we don't see it in the area. It's just not chemically addictive like other substances are. So this is how I think the court should view the case and why I summarize those facts. This is two people who created, using some pretty mundane equipment with substances they ordered online, instructions they likely found online, to create dimethyltryptamine, and they did so. There's no evidence they distribute it into the community. Manufacture of a controlled substance does not require proving that, and the state had no intention of arguing that when it charged it. What they pled guilty to then, that manufacture of a controlled substance and the maintaining a drug trafficking house, that's how those offenses should be viewed, and why we're not arguing for a larger sentence than the 2 years initial confinement on this. That is, a person manufacturing or creating something for themselves, whether it's growing weed or condensing down dimethyltryptamine out of bark into a more concentrated form for themselves, is different than someone who, as the PSI writer indicates, would be a problem, someone who's distributing it to the community. And we have no evidence of that here. So that's why I summarized those facts and wanted to address what some of the things DOC wrote there, because I think that the Department of Corrections viewed this how they view other substances that they maybe understand better, and other labs that they understand better. We use our local writers for these, and we know that methamphetamine labs are very dangerous, and this is not a methamphetamine lab. That being said, I do think that this small amount of prison is necessary because of the history of Mr. Chaffy, because he's been to prison in the past, and because, you know, we can show through forensics that he touched something within one of the guns. I believe his fingerprint was on one of the casings. That, and just in general, he was present, and those guns were pretty openly stored there during the course of the divorce. And the guns there with the presence of the other items is concerning. What the state's goal would be with the 2 and 6, or the sentence suggested today, being asked of the court today, is there would be a punishment component with the 2 years initial confinement. The extended supervision component is important just to make sure he doesn't do it again. Ironically, because the state lab tested it, they now know that this process does work. It does create DMT, and they could just do what they did before and just do one extra step and be able to have it in the concentrated form. So having that supervision to just make sure that doesn't happen, and make sure there's treatment and dealing with the mindset that leads into wanting to create an experiment with this substance, would go a long way to preventing it in the future. Thank you.
Thank you. Ms. Perrin.
Thank you, Your Honor. Upon reviewing the history of Mr. Chaffy, it's he doesn't have the worst criminal history. There's some minor, they're serious issues, but they're not felonies. The DUIs and some of the other issues are misdemeanors. They're indicative, however, of substance abuse issues. And I think that comes out clearly in the alternative sentencing report. Mr. Rooney did an evaluation also with that report that demonstrates a need for treatment. We would ask the court to make him eligible for earned release because of that. And Mr. Chaffy would ask the court for a lower sentence than either report request and from the prosecution. He would ask for a year sentence. He's been in custody for almost exactly a year. Haven't quite added that up. It looks like his initial appearance was on May 7th.
Arrested on April 23rd, 2025.
April 23rd. And so that is the sentence he asked for. He states that he had a pretty good childhood. He's got some education beyond high school. He has some skills as far as work skills. Mr. Chaffy has potential to support himself and his children when he's out in the community, and he has potential to contribute in the community in a significant way. And so we asked the court to consider all of those issues and everything that the prosecution said and sentence him accordingly. Thank you.
Thank you. So what is happening with his conviction from Cerro Gordo County, Iowa?
This is
So
a
Ms.
fascinating
Chamberlain was
turning
with you at
point
that
in the
time?
hearing. Notice what
Yes.
the prosecutor is
arrested?
doing here.
I believe
He
so.
isn't arguing that DMT production is
And she
acceptable.
wasn't convicted
Instead,
of anything?
He's
Not
narrowing
that
the
I'm aware
scope
of.
of the crime by
That I was
separating
aware
this
of, or
case
I
from a
would've
typical drug
seen it
trafficking
in the
operation.
PSI, but I did
He's
not.
emphasizing there was no evidence of distribution,
What
no
else do you want
large
me to
cash
know?
seizures, and no established
I had a
customer
good
base.
upbringing.
In
You know, I grew up
sentencing,
on a farm.
those
I got a good
distinctions
work
can
ethic.
significantly influence how
After
severe
my
a
first
punishment
divorce,
the court
when I was
believes
getting
is
divorced and
appropriate.
my first wife
What
left
do you
me,
think?
I fell
Should
off
someone
pretty
who
hard. I started
manufactures a
drinking heavily,
controlled substance solely for personal use be
trying to kill
sentenced
some of
much
the
differently than someone producing it
pain
for
and
sale?
anguish of
From November 6, 2024, Dominion control of a firearm. He was sentenced to 5 years of prison with 3 years of state probation. But has that been affected by this case?
Not that I'm aware of.
Do they even know about this case?
yes, I do.
Yes.
And are you just waiting to hear from them if there are other steps?
From Your Honor, from what I've gathered is that my probation officer in Minnesota said that he wasn't sure what they'd want to do, but since I hadn't had any other issues on probation, so he just told me that if I was released, that I needed to see him within 72 hours.
So wait and see. We'll see what happens approach, huh?
Yeah. So I don't know if they'll give me a violation and then the time I sat counts towards a violation or what they wanted to do.
Because that's a serious case and a serious sentence. And then the other prison sentence with the assault, second-degree dangerous weapons, that was your first really serious
Yes, Your
conviction.
Honor.
And that's where you went to prison. Mr. Chaffy, is there anything you want to tell me, you want to let me know as it relates to this matter, to your history, to your criminal record? Tell me a little bit more about that whole Iowa matter and case, and because that seems like a harsh sentence. I don't know anything about the Iowa justice system, to be
Yeah. I honestly, I don't know anything about the Iowa criminal justice system really either. We were traveling through town and got pulled over. There was a couple, Miss Chamberlain's guns were on the bike and we got taken in. They gave me, I sat in jail down there for 17 days or something, and they offered me a plea deal and I took the plea deal. They, 3 years probation. I think I got a year left of that probation.
Oh, wow, that was quick. Offense date, August 31st, 2024. Conviction date, November 6th, 2024. Quick turnaround.
Yep.